All right. Good evening, folks. Just me tonight, just doing my solo thing here, kind of getting back to the grassroots of Kirk's Law Corner. How I originally started this here was to teach the law and what your rights are, where they come from in law as it is written, and how to effectively defend them. So with us, our normal shows on Wednesdays and Fridays now, with being overtaken by the E-clause stuff, which is essential to restoration of our rights and taking back control of the servants in government. That'll be Wednesdays and Fridays. So that's with Chris and John. And again, I just want to get back to the grassroots here of what I originally intended Kirk's Law Corner here to be, was to educate people on what their rights are, where they come from in law, and how to effectively defend them. The stuff that we're teaching with the E-clause and petitions of remonstrance is, it is a right retained by the people. It is part of how to redress your grievances with bad actors in government, bad policy, and all that good stuff. But we still need to learn the fundamentals. So getting back to basic fundamentals, and like I'd stated before, that we were going to try and do some videos on, how to do the basic stuff, the basic knowledge that we need. We need to have the groundwork before we do the roof on the house. We got to prep the ground. You got to do the plumbing, you got to do the electrical, and then you pour the foundation. And I'm gonna run through this stuff that I've got here to show you what your rights are and kind of essentially where they come from and how they come from there. Michael, my rights are what I say they are, said a sovereign people who answer only to his creator. That is absolutely correct. That is a very factual statement. And the fact is that's what the term lawyer is. One who is knowledgeable on the law. One who speaks the law, right, is a law sayer. All three of those terms put together is a pronoun. That's what pronouns are, is a bunch of phrases, words and phrases put together into one word. So, if you split lawyer in half and put SA in there, you have law sayer. That's it. So we have to be the law sayer, not an attorney. This is something fundamentally that we need to fully comprehend here, is when you hire an attorney, their first line of allegiance is to the court and then to the public and never to the client. And the root word of attorney is attorn, which is to attorn you, right? Attorn ye, attorn you, to take your, another pronoun, to take your property and give it to somebody else. Well, what is your property? Your property is an aggregate of guaranteed rights. So let's get into those guaranteed rights. They come from where? They come from God, right? We have creator endowed rights. We don't have man created rights. Those would be, in essence, civil rights or political rights. So with no further ado, let's jump into some screen sharing. I'm going to show you some documents. Where do I okay, I'll just do the screen. And you can see what I watch. Hey, look at that. There's that -1 times a -1. There's the Hallett Doctrine right there, right on my screen every time I run this. So let's get into what I got here to share. This is from American jurisprudence. American jurisprudence. Jurisprudence is the science behind the law. So this is the American science behind the law. This is from the second edition, September 2016 update. This isn't some old stuff, right? This is fairly recent. This is my trip down to the law library, and I pull this stuff up on the computer and save it on my little flash drive over here and take it home so I have it. So this is the one that I keep talking about, where natural rights and civil rights have nothing to do with the establishment, support, or management of government. This is it, right here. Okay. Civil rights, in general, natural, political, and social rights distinguished. Okay. Natural rights have been described as those rights which appertain originally and essentially to each person as a human being and are inherent in his or her nature. So we'll correct these words as we go through here. As a man, mankind, human being is defined by them as a monster. So the three main terms that you need to know: you're either a man, a woe man, which comes with their own warning label, you know, whoa man, and one of the people. That's it. You're using any other term than that, that's word salad. They're trying to trap you into some sort of word salad language to drag you into their jurisdiction. Jurisdiction being the words, jurisdiction, the words of that law. Juris being the law, pardon me. Juris being law, diction is the words of that law. What law are they talking about? So this is when I get into objecting to the jurisdiction and demanding proof of jurisdiction. This is exactly what I'm talking about. What words? These words right here. This is jurisdiction, okay? As contrasted to civil rights. So there's something different between natural rights and civil rights, clearly, as it states right here in the science behind the law. I'm actually going to pull this up on my phone so I can try and keep up with any comments that you might have out there or questions as we go through this. No, off. I don't want that sound. Let's see what we got here. Did it allow me to tag myself? Nope. I tagged myself. Pull this up. Come on. Share this. Of course not. Let me share. Copy link. Yeah. Hi, Neely. Hello, Lynette, Richard, Don, and 7 others watching with us. Susan's on. All right. All right. So as contrasted with civil rights, which are given, defined, and circumscribed by such positive laws enacted by civilized communities as are necessary to the maintenance of organized government. So where do we find civil rights? That would be the Bill of Rights. Bills of Rights are merely declaratory of the common law, which I'm going to show you that in American jurisprudence. Okay. So natural rights, right? Those are creator endowed rights. Those are unalienable or unalienable. Can't place a lien on them and you can't take them away. Plain and simple, they cannot be taken away. Your right to life cannot be taken away from you, except by due course or due process of the law. And that would be followed under civil rights or natural rights, because naturally you have the right, per the Bible, to go through a certain process, right? It has been said that political rights are included within the more comprehensive term civil rights, but that they are differentiated in the political right, in that a political right is a right exercisable in the administration of government. This is why we have all political powers inherent in the people. The people have the right to alter, reform, or abolish anything at any time we deem it necessary, right? Because we have a very unique government. It's one of a kind in all of existence of government, in the entire history of law and in the world history. This is the best form of government, where we are self-governed, Nobody dictates to us what our natural rights are and how we exercise them, right? And then the civil rights belong to the people of the society. Naturally, you acquire those civil rights by being an American, not an immigrant, not somebody who's here illegally. You do not have these rights if you're not an American. Plain and simple, you do not have these rights if you're not an American. Okay? This comes from right here. Enacted by civilized communities as are necessary to the maintenance of organized government. If you're not an American, you have no civil rights here. These come from the civilized communities in part of the organized government, being one of the people. You can't be one of the people if you're not from here. Okay, so, or a right to participate directly or indirectly in the establishment or management of government. Now, this is where it gets good. While civil rights have no relation to the establishment or management of government. Now, Beauvair's Law Dictionary from 1856 says establishment, support, or management of government. Our rights do not have anything to do. So when we're talking about civil rights have no relation to the establishment, management, of government, what does that make for natural rights? Natural rights most definitely have nothing to do with government. Political rights have also been distinguished on the ground that a civil right is a right accorded to every member of a distinct community or nation, an American, which is not necessarily true with regard to political rights. Civil rights have also been distinguished from social rights and privileges, and has been pointed out in this connection that the purely social intercourse and relations of individuals cannot be enforced by law. What? They cannot be enforced by law and are not guaranteed by any constitutional provision. Imagine that. Social rights or privileges. But we have to understand what our social rights or privileges are, right? Like drinking is a social right. Alcohol, consuming alcoholic beverages is a social right. You have to act responsibly. So here's all these cases cited in the footnotes. So if you want to do any deeper investigation into this, there they are. These ones you will have to go to the law library and get. This is the crazy part. Like I go on to Justia and I try to put these in. Google Scholar, none of these cases will show up because they don't want you to have them. Not easily accessible. I do have Blackshire versus NAACP. It's a good one. So that's the end of that document. Now, when we get into, why is that weird? Some more American jurisprudence. Oh, crap, bro. Please try to keep your questions focused on the subject matter at hand. I don't want to go off on tangents, but one of the questions here is then how do we get them out of the government that have already been elected? How can we get them out of Dearborn, Michigan and Minnesota? It's called impeachment. And that's through a petition of remonstrance to impeach them and remove them from duty because they're not supposed to be there. But you have to know the law. You have to know where it says they're not allowed to be in there because they're not an American. And they're not following American values and the law of America, the law of this nation. So here is American jurisprudence again. This is August of 2017 update. I got this right after that. This is it's the 16th volume, American Jurisprudence, Volume 16, second edition, Constitutional Law, Section 98. Prohibitory language stated in a constitution is nearly always construed as mandatory. Now, Mason's Manual, Legislative Procedure, aside from the 10 principles, the first principle being the group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers that they do not have. They're openly admitting that they sometimes take jurisdiction on a subject matter and create legislation that they don't have jurisdiction over. How do we address that? That's a petition of remonstrance for impeachment. Become a bad actor, bad policy. No, no, no. You're not supposed to do that. But that's how we've been derelict in our duty to maintain the republic. Chapter 2, Constitutional Provisions Governing Procedure. Section 6, Clause 2, a constitutional provision regulating procedure controls over all other rules of procedure. 7, constitutional requirements concerning procedure must be complied with. Number 1, being organic in character, constitutional provisions stand on a higher plane than statutes and are mandatory. Constitutional provisions providing exact or exclusive time or methods for certain acts are mandatory and must be complied with. Constitutional provisions that are general in nature and not exclusive may be directory. Okay? So constitutional provisions are mandatory. No ifs, ands, or buts. Okay? So this is what we're going to talk about right here. It's what it says here, right? Constitution nearly always construed as mandatory. State versus Ham. Well, we don't even read this. Again, this is case law crap. If directions are given respecting the time and mode of proceeding in which a power should be exercised, there is at least a strong presumption that it was designed to be exercised in that time and mode only. Constitutional provisions imposing duties upon the governor and the legislature have been held mandatory. That's right. Why? Because you're the servants. We are the masters. We put it in writing. These are the instruments of government that create your emolument. Your seat in government is created by these documents right here, right? This is what the people write. That is the government. Not the people themselves, but the documents is the government. However, a constitutional article providing that all laws are to be made for the good of the whole and the burden of the state ought to be fairly distributed among its citizens presents no constitutional restraint on the legislative power of the legislature because it was addressed to the legislature by way of advice rather than a command. Well, this verbiage here is trying to give them power that they don't have. And see, that's why I go into these kinds of books in the annals of Congress. And as our founders and stuff like that met in the Constitutional Convention, and we're talking about the Bill of Rights and creating the Bill of Rights, they talk about certain things like the general welfare, right? What that actually means is their scope is very, 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 very limited. And it works one way. And it's supposed to protect the people from all things foreign to the people. That's the general welfare. Not to dictate to the people what's good for the people, but what's not good for the people is to be, right, regulated and dictated that no, we're not going to let that here. Sorry. We have to protect the general welfare of the people. That's your job, is to protect the general welfare of the people, not to dictate to the people what you think the general welfare should be. So let's go down to section 100, which I quote from all the time, right? Right here. Volume 16, American Jurisprudence, second edition, Constitutional Law, section 100. A constitution is usually a declaration of principles of the fundamental law. What was that in the Law of Nations there, Book 1, Chapter 3, Section 34? Congress, the legislature, does not possess the authority to alter the fundamental law, nor the Constitution, right? They do not have that authority. They are the servants. Servants do not dictate to the people what the law is. We lay down the law prior to creating government. For that reason alone, you have to lay down the law first. And that's why it's a declaration. Declarations lay down the law, and they come before the Constitution. And they're principles, like the plus sign, the minus sign, the division sign, multiplication sign. Those are principles of mathematics. You cannot alter those principles. If you were attempt to alter those principles, you would fundamentally mess up mathematics on a grand scale, and we can't do that. Not going to happen. Not on my watch. So, many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing, that is, operative, without any necessity for further legislation. That's why the First Amendment, or the first article of the Bill of Rights, because these are articles in addition to the Constitution as an amendment of the Constitution, it says Congress shall make no law. That's right. Congress shall make no law respecting natural rights and civil rights. Those are that's the fundamental law. You can't alter that stuff, right? There is no necessary legislation. There's no necessity there. We don't need you to legislate for us in all cases whatsoever. In fact, that's a declared act of tyranny in the Declaration of Independence. So that would be an act of treason, okay? So criteria which may be relevant in determining whether a constitutional revision is self-executing or not include a description of the right in detail, such as the means for its enjoyment and protection, the absence of any directive to the legislature for further action, a particular informative legislative history as to the provision intended operation, and a consistency of self-execution with the scheme of rights established in the Constitution as a whole. So this is part of the reason why James Madison, in writing the Bill of Rights, talked about how it would, the argument was made, well, why should we even do a Bill of Rights? Our rights are supposed to be self-evident at this particular point in time in history, in 1776, right? So Madison was like, well, if we were to list some, there would be people out there, tyrants, who would try to construe that as, well, these are the only rights you have, and that means that we have control over everything else. Because of everything that they've been through, they knew exactly how tyrants think, right? This is in the annals of Congress, but it's also in the annotated Constitution under the 9th Amendment. This is the reason why Madison wrote the 9th and the 10th Amendment the way he did. There are other rights retained by the people that are not enumerated in this Bill of Rights, and they shall not be denied or disparaged, which means don't make fun of me when I claim these rights. As the law sayer and the bringer of the law, if I assert a claim of a right, don't make fun of me. Don't try to deny that. I'm saying it and I'm claiming it. Unless you have some sort of evidence to prove otherwise, that right doesn't exist, screw you. Kick rocks, dude. Get off my property. These are aggregated guaranteed rights. You're trespassing. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights, that's plural, more than one, because every state, in order to form a more perfect union, this is the way our founders thought. If we create this union, each and every state writes their own Bill of Rights. You'll find it in the first article of your alleged Constitution. It's a Bill of Rights. In history, this is how it's been done, right? You do the Bill of Rights first, then you do the Constitution, because you have to have the law laid down before you ordain and establish the Constitution, the government, the format, what I call the instruction manual. Okay, so constitutional provisions and bills of rights are those merely declaratory of the common law. This right here destroys every single argument that people would make that case law, stare decisis, is the common law. Yes, in England, that is the way they do it, and still do it. When you go to their parliament and do their parliamentary rules and parliamentary practices, if you prevail, whatever you create, case law, the common law of England. This is how they do it. This is what we Brexited from, because they knew how the judiciary was, and they wanted to avoid that in the American common law. And so the way our founders set up our nation, right? The Lee's Resolution separated us from Great Britain, written on June 7th, 1776, ratified July 2nd, 1776. Imagine that, 2 days before the Declaration of Independence. The Lee's Resolution is actually the document that was the separation. But again, we use declarations to lay down the law. So that's what the Declaration of Independence is about, is telling the people and all the world, right? Let these facts be submitted to a candid world, that these are hereby declared acts of tyranny known to tyrants, which is treason in our nation now, because the way our founders set up the American common law and our American law, America as the nation. Okay, so bills of rights and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct, such as Congress shall make no law. That specifically prohibits Congress from making law regarding natural rights and civil rights, which have nothing to do with the establishment, support, or management of government. Okay? What's the Second Amendment say? The second article of the Bill of Rights, right? The right of the people to keep and bear arms shall not be infringed. There is no language there that says Congress shall have the authority to make legislation regarding this act or this section, which you'll find in other parts of the Constitution. You'll find that there are in certain amendments and certain parts of the Constitution that says Congress shall have the authority to make legislation regarding this. That language is missing from all of the Bill of Rights. Why? Because it's part of the fundamental law, the common law, principles, the stuff no man can change. Not even us. That's why we're not a democracy. That is the beauty of having a republic. We go by the rule of law. Those principles dictate the correct answer every time. I don't care about your feelings. Lady Justice doesn't care about your feelings. Law, in essence, is black and white. It is either morally right or morally wrong. Plain and simple. There is no in between. There is no gray area when we're talking about law. Murder is murder, right? You commit murder, that's a crime. That's immoral. That's a deprivation of the right to life. Fundamentally, that's at the fundamental law, the common law of America. So, Clear distinction exists between the questions whether a constitutional provision is mandatory or directory and whether it is self-executing or requires legislation in order to give it effect. Well, I think where it says the right of the people to keep and bear arms shall not be infringed is pretty clear and is mandatory, and it is directory. You don't have the authority to make any legislation because the word infringe dictates that, right? So clear distinction exists, right? Clear distinction. So here's some case law on that. That's all right here. You can look those up down there at your local law library. You're not going to find these on Google Scholar. You're not going to find these on Justia. You might find one or two here if you get lucky. But see right here. As to whether a constitutional revision is mandatory or directory, generally see 97 and 99. 97 is the word shall. Imagine that, where it says shall. Let's get into that. Shall, that word shall. Is it this one? Oh, that's 98. I think it's not 97, right? Okay, the courts usually hesitate to declare that a constitutional revision is directory merely since the legislature may tend to disregard provisions which are not said to be mandatory. Accordingly, it is general rule to regard constitutional revisions as mandatory. So in general, the general rule is if it's a constitutional revision, it's mandatory. It's mandatory, it's mandatory, it's mandatory everywhere. Don't touch that shit. It's not yours. That's not your subject matter. You don't have jurisdiction over that. Leave it alone. Don't trespass upon our rights. It's been laid down. Our property. Get off of it. And not to leave any discretion to the will of a legislature to obey or disregard them unless it appears from the express terms thereof or by necessary implication from the language used that they are intended to be directory only. The presumption or rule that constitutional provisions are mandatory and prohibitory unless by express words, there must be words in there that says you have the authority over this. They are declared to be otherwise applies to all sections of the state constitution alike and is binding upon all branches of state government. This is right where we go to Article 6, Clause 2, where the judges in every state shall be bound thereby. If anything in the Constitution or laws of a state to the contrary are notwithstanding, which means they're void for any effect from the inception, not from the day you go to court and brand it as unconstitutional. See Marbury versus Madison, 5 U.S. 137. So strong is the inclination in favor of giving obligatory force to the terms of the organic law. The organic law. There's another term, right? What did I just read out of here? Constitutions being organic in nature. That it has even been said that neither by the courts nor by any other department of the government may any provision of the Constitution be regarded as merely directory, but that each one of its provisions to be treated as imperative and mandatory without reference to the rules distinguishing between directory and mandatory statutes. Nonetheless, if a constitutional revision contemplates the enactment of implementation of legislation, the provision should be interpreted as establishing general guidelines for the forthcoming legislation rather than mandatory directives to its content, absent clear language to the contrary. Kind of twisting that there, trying to reach, they're trying to grab at our rights. No. If it's the fundamental law, you cannot change it. You don't have any authority over that. None. Rather than solve the problem with which is concerned, the consequences must be accepted as inherent in government by law instead of government by edict. So maybe it is 97 that talks about the word shall. Prohibitory language stated in a constitution nearly always construed as mandatory. If directions are given respecting the time and mode of proceeding in which power should be exercised, there is at least a strong presumption that it is designed to be exercised in that time and mode only. Constitutional provisions imposing duties upon the governor. Okay, we already just read this. What? That's 98. Maybe it was 90. No, maybe it was 99 then. The word shall is right here somewhere. There it is. Shall or may. Okay, section 99. When interpreting Constitution provisions, the word shall is presumed to have a mandatory meaning. Patterson Recall Committee, Inc. versus Patterson, 209 P3D 1210. Looks like Colorado Appellate Court in 2009, right? So there it is. The right of the people to keep and bear arms shall not be infringed. That is a mandatory meaning. Congress does not have the authority to make anything regarding our right to keep and bear arms. The second that we have them making law regarding our rights to keep and bear arms, you know that something's up. And we'll go right back to the Brady Bill from like 1956, I believe it was. Maybe it was, no, it wasn't 1956, was it? I have to refresh my mind on that one. The Brady Bill is where they were like, oh, well, you got to do a background check and blah, 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 blah. And this is where we get into bills of attainder. Bills of attainder are legislation like, if you do this over here, you lose this right over here. No, where's the due process of law to deprive the fundamental right? That's what our founders put in the Constitution. Article 1, Section 9 to the federal, and Article 1, Section 10 to the states, a prohibition on bills of attainder, bills of pains and penalties. The short definition is legislation and punishment. If we have legislation out there that's prescribing a punishment, if you do this over here, that bypasses your right to due process of law. No, not in our form of government. I don't think so. Get that crap out of here. Right here. Especially where it says shall not be infringed. There's a reason for that. Because our founders knew exactly how tyrants work. So there we have it right there on shall, the word shall, right? May says, well, they can, right? Accordingly, the word may should not be construed as shall in any constitution unless from the whole context the purpose plainly appears to be mandatory, although occasionally the word may has been interpreted to mean shall or must, right? So must is one of the new words that they're wanting us to use instead of shall. But, you know, like the 10 Commandments, thou shalt not murder. Shall is very mandatory. It's directory. You shall not do that. And we don't need government to write some law that says you can't do that. What we can do is say, all right, at the common law, the fundamental law, the organic law, that we know fundamentally, principally, that murder is wrong. What is the punishment for murder? That's what we can do, right? But that's supposed to go through the common law, because that is the common law, not in any court of the United States, because the people aren't bound by the Constitution. Article 6, Clause 3 is the one that says, this is a good one. People need to read this sucker. Well, I'm looking at the Idaho Constitution. That ain't going to get me what I want. Article 6, Clause 3 of the Constitution of the United States of America. Okay. So when we talk about oaths of office, right here, okay, everyone, the senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states shall be bound by oath or affirmation to support this Constitution. Okay? But no religious test shall ever be required as a qualification to any officer of public trust under the United States. Right? What does that say? That means everybody. If you're getting a paycheck from the Department of Treasury, you are to be bound by this, because this is the process to bring your job into being. And if we've got people out there impersonating public officials that this Constitution doesn't allow to exist in our form of government, that would be, first of all, treason against the legislature, a capital offense, for creating that job, that emolument, right? Because all of these jobs in here, the governor, president, you know, the House and the Senate, all that, all those employees, elected officials, they have to be bound by this. And everybody who works for us as a servant in government, they have to be bound by this. And if they're not, they're impersonating a public official, a government official. Okay? That's an emoluments violation. That's scheme, scam, fraud. So let's get rid of that one. I've pretty much covered that. The bills of rights are merely declaratory of the common law. That's the good stuff there, right? Here's Christopher Hallett's on this parliamentary inquiry that he did. And what we have here is more of the Mason's manual that I wanted to share. But we've shared this before. So when looking at this, what is the job description of E-clause, right? Malitus hominum est obviendum. I'm not very good at Latin. So this is it right here. This is what we're doing with E-clause. The malicious designs of men must be thwarted. That confidence scheme, confidence scam, everything that they put in by design, that's a malicious design to deprive us of our fundamental rights, it must be thwarted. Integrity of legal, lawful process issues as unlawful emoluments, pyramid schemes, sham prosecutions, defective business practices, etc. Lawful. Notice we use the word lawful a lot here, right? He's making the contrast between legal and lawful. And in law in itself, legal has to do with a contract. Plain and simple. Anything other than that, it's lawful or unlawful, full of law or not full of law. In other words, full of crap. If it's unlawful, it's full of crap. It's an emoluments violation. It's an evil, malicious design of men. Lawful and equal enforcement under the Constitution of the United States of America and the Constitution of the several states pursuant to Article 4, Section 2. It's also Article 4, Section 1. The full faith and credit clause, right? Yeah, full faith and credit to the records and judicial proceedings of all states. The public acts, okay? All right, advising the courts through this process in accordance with established due process of law as I redress my grievances with my legislature, as written in the Constitution, will pay due respect to Lady Justice in accordance with the Judiciary Act of 1789 when they enacted it, right? The questions to be answered in this case, this is what he's put in for parliamentary inquiries here. Justice comes before liberty. Imagine that. Lady Justice comes first, even though liberty is the foundation of all of our rights, right? Clear back to 1215 with the Magna Carta. Justice is to be denied to no one. Right and fraud never abide together. So there are 8 elements of a contract. In order for that contract to be lawful, not legal, lawful, there are 4 main elements that must, shall be adhered to. Okay? We'll get into that later. But right now we're trying to do fundamental stuff. So how is it anything less than treason to continue to deny the people true justice under the law by not enforcing liars, perjury statutes? That's the 9th commandment. Thou shalt not, right? Thou shalt not bear false witness against thy neighbor. You are not to make false statements against your neighbor. Your neighbor is everybody within America. All right? Perjury statutes against government actors in positions of emoluments, knowing these 3 most fundamental principles and practices of law right here. These are 3 fundamental principles because these are maxims of law. These are principles. Maxims are principles of law. This is part of the rule of law. This is 2 + 2 = 4. I don't care about your feelings. Justice comes before liberty, and justice is to be denied to no one. Right and fraud never abide together. Nope, couldn't, Chris. I told you that on Friday, that I was going to take back over Monday and go back to my original intent of Kirk's Law Corner. So thanks for joining, Chris. How does the court reconcile? Hey, notice what I'm talking about here, brother? How does the court reconcile, hold accountable the Bar Association and using the Declaration of, this is great, using the Declaration of Independence, declared acts of tyranny like a checklist of things to do in these cases to perpetuate litigation, and those actions not constitute treason on the court? For those of you that haven't read the Declaration of Independence, let's go ahead and read these declared acts of tyranny. I actually brought this up for the Mason manuals thing, and as well as the 10 Commandments. But this is such just short and sweet right here. I can't resist sharing it. This is such great pinpoints in law in itself. So, how is Title IV or TAL of Social Security Act unlawful emoluments anything but practicing barratry? That's how you spell barratry right there. B-A-R-R-A, try. Barratry. And extortion under color of law. Knowing unlawful incarceration is the end result is clearly established in this case because Chris got, arrested for not paying his child support based on an unlawfully obtained procuring false documents through malicious prosecutions, false statements, perjury made by government officials and bad actors in government who lied against Chris and stripped him of his rights unlawfully without due process, and then false arrest and imprisoned him. Oh, but he got him. How is the Adoption of States Family Act of 1997 anything less than state-sponsored human trafficking? Well, what I just went over before, natural rights and civil rights have nothing to do with government. Why are they adopting the Safe Families Act in 1997 when Congress has not the authority to do that? They don't have that jurisdiction. You cannot do that. The law already dictates. The law that we, the people, laid down back in the day. The fundamental law, the organic law, the American common law. No administrative judges. They don't exist. We're supposed to be at the common law here. See the 7th Amendment. You shall not have no other gods before me. You shall not, make for yourself any idol. Thou shalt not have any other idols before me. Something like that. I don't know where you got these exactly, but it's a little out of my memory of what I read. I know they don't say it like that, but I know you cleared it up to help bring it up to modern English, right? So these guys can comprehend it because, thou shalt not commit murder, and thou shalt not steal, thou shalt not cover the neighbor's wife, thou shalt not bear false witness against the neighbor. They might not quite comprehend that very well, so you got to reword it for them. So here's that 10 principles that govern procedure in group decision making. That's right out of here. This Mason's Manual on Legislative Procedure. Make that just a little bit bigger. The group must have the authority to take the actions it purports to take. Did they have the power to create that Family Safe Act? No, they most certainly did not. Jurisdiction must be given, being in our form of government where we are self-governed, and consent must be given. Consent was never given. Natural rights and civil rights, Congress shall not have the power to make law. Congress shall make no law, plain and simple. Not regarding natural rights and civil rights, none. Punishment, maybe, if the common law doesn't cover it, but it does. Eye for an eye for murder, right? That's what the common law says. You commit murder, you're supposed to be put to death. That's the remedy in law. Ish, right, Chris? Ish. Kind of had to reword it so they could comprehend it better. There must be a meeting of the decision-making group when authority is vested in the group collectively and not merely in the individual members of the group. To make a decision, the group must meet and make up its collective mind. So you can't just have a couple people say, well, we're just going to do this. No, not how that works, not in our form of government. A proper notice of the meeting must be given to all members of the group. I want to get down to number 9, I believe. There must be no fraud, trickery, or deception resulting in injury to another member. A person is entitled to protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. No fraud or trickery. Imagine that. Because what was that fundamental principles? Rights and fraud cannot abide together. They just can't, right? To be valid, any action or decision of a body must not violate any applicable law or constitutional provisions. So when they write all these laws about guns, and your right to keep and bear arms that shall not be infringed, which we just covered there, shall not, is mandatory. There isn't anything in there that says Congress shall make law. In fact, the First Amendment says no. Congress shall make no law. The decision-making procedures of any body must comply with the applicable provisions of any local, state, or federal law. It is governed by any statutory or court-made law, including provisions of the constitutions and charters. Imagine that, court-made law? In our form of government that our founders set up, in the clear distinctions of powers, separation of powers, the judicial branch doesn't have the power to make law. That's what we separated from in England, right? This is the American common law. That's bills of rights, not case law, not stare decisis. So there you have it. The special law detracts from the general law. That's a That's that lex. That's that Latin stuff. So now, where do our rights come from? This is law.cornell.edu, and come in here to get the law. I have my page set automatically to come to the Constitution in my bookmark here. But when it comes to the main page, you'll have to go scroll down and you'll see it. And then when you get to here, you'll have this up here and you can go look at all this stuff. Imagine that. State law, uniform laws, federal law, and world law. Okay. Here's your federal rules of procedure: appellate, civil, criminal, rules of evidence, bankruptcy. Okay. Here's your United States Code. Here's the CFR. Here's UCC, Uniform Commercial Code. Constitution. Okay. Now, what I love about law.cornell.edu is they tie the annotated Constitution in together here. So when you see this here where it says see explanation, this actually takes you to the annotated Constitution. So I want to show you the history of our law right out of here, right? This is current stuff in the 6th Amendment. Jury trial, right to confront, right to counsel, not to an attorney, but to counsel. Okay. C, explanation. Let's go there. Let's go take a look at this. We're going to go to the source. We're talking about the right to a speedy and public trial here, right? This would be what? Would this be a natural right, or is this a civil right? If it's from the common law, it's a natural right. Naturally, right? Even though it could be construed as a civil right, and in history, what they've said is, well, what we're going to do for it to be more proper is we're going to consolidate natural rights and civil rights together. And that is to give that effect of, well, we have authority over that now, right? No. So, source and rationale. What we're talking about here is logic and reason. And the source of the logic and reason, and why it is very logical and reason, rationale, right? Reality. How we rationalize this logic, we use logic and reason. All right. The Magna Carta. Why are we talking about the Magna Carta in 2019? Because, right, declared, this is from section 40, right here, chapter 40 of the 1215 Magna Carta, and a portion of the chapter 29 of the 1225 revision, right? We shall not deny nor defer, and it's actually, we will sell to no man. We shall not deny nor defer justice and right, neither the end, which is justice, nor the mean, whereby we may attain to the end, and that is the law. Much the same language was incorporated into the Virginia Declarations of Rights. Whoa, wait a minute. Say it isn't so. The Virginia Declaration of Rights in the annotated Constitution, see that, what we're in right here? U.S. Constitution annotated. Rights of accused, right to a speedy trial, source and rationale. Okay. This is called succession of law. Rights cannot be diminished through succession of law. Law as rights, right? Bills of rights being merely declaratory of the common law. The law carries forward. All of the bad stuff goes away, and this is the new, right? But all rights carry forward. As it is written, you cannot diminish what rights have been declared, as it is written. Okay, you can expound on it. You can provide further protections. You can write it how you want, but you cannot alter it. You cannot diminish the rights retained by the people as man, as a creation of God. In our nation, that's the way we look at it, and that's the way it's laid down in law. So we have to comprehend that the Virginia Declaration of Rights is in our succession of law. Why is it so crucial to comprehend this document? Because this is the document that lays down the law. Remember, we went over declarations laying down the law. This is the declaration that lays down the law of our ideology of this nation. Okay? So I'm going to take you to another beautiful, beautiful site. You can read from here to your heart is content. I have spent years reading, not necessarily from just this one, because there used to be a different site that I used for the same information, but it's like it disappeared. This is Avalon. This is law.yale.edu. Look at all this stuff that's on here, right? And in fact, let me show you one other one that's great. For the argument of, oh, slavery, right. Let me blow your mind here real quick. That's the Declaration of Rights. Where's the statutes at large? Here we go. Whoa, what's this? 1794, an act to prohibit the carrying on the slave trade for the United States to any foreign place or country. March 22nd, 1794, Yeah, we were working on abolishing slavery clear back then. The 14th Amendment is a scam. It's a scheme. It's a fraud. Right? Here we are, 1850. Imagine it came. Now, look at this. Look at this timeline, folks. 1794, 1800, 1803, 1807, then 1850. What happened right after this? 1861 was the beginning of the Civil War. And we've all been taught that the Civil War was about abolishing slavery. No, most certainly was not. It was about states' rights. Why would a group of people that are trying to be freed from slavery fight to keep themselves enslaved? That's an oxymoron. And the argument is, oh, well, both sides owned slaves. That's true. They did. But by this particular time, slavery was supposed to have already been abolished. But let me tell you, the same people we've been fighting against since 1215, since 600 AD, is who we fought against in 1861 through 1865 with the Civil War. That's what it was really about, trying to take our rights, our individual sovereignty away from the people, from the states, and kicking these people out of our nation, right? Back to the War of 1812. So it's like, got to do your research, folks. Don't always believe what my grandpa used to always say. Only believe half of what you hear and none of what, only believe half of what you see and none of what you hear, right? You always want to go do your own research. And there's plenty of great illusionists out there that can deceive your mind, your eyes, quite easily. We have magicians and that kind of stuff. Confidence scheme, confidence scam, trickery, right? It's all a trick. As long as they can convince you to believe this crap, you're gullible, you're going to buy it. I don't think so. So let's go look at the Virginia Declaration of Rights. Why is it so important? Because it is, oh, look at that. There's the Constitution of Virginia, June 29th, 1776, which they've removed from here. I'll show you here in just a minute. Because they don't want you to know about that one. It used to be on here and I got it. I already got it saved. I've got it saved with the Virginia Declaration of Rights, right? Bills of Rights, first article of the Constitution. This is the way it's done. You do the Bill of Rights, except for back then, they actually did them separately, two separate documents, because the Constitution is supposed to be the government and the Bill of Rights is supposed to be the form, which you're going to find, I'm going to show you right now. Where is it? There we go. Notice the date, June 12th. Okay, so we have a timeline here. The Declaration for the Causes and Necessity of Taking Up Arms, which is June 6, 1775. Then you have the Virginia Declaration of Rights, actually the Lee's Resolution, June 2nd or June 7th, right? June 7th, Lee's Resolution. That Brexited us from Great Britain. Then you have the Virginia Declaration of Rights, June 12th, the Virginia Constitution from June 29th. Then you have the Lee's Resolution being ratified July 2nd. Then you have the Declaration of Independence. Virginia was the first constitution of the United States of America, as other countries, states, okay? The Lee's Resolution converted us from colonies of England into individual sovereign states as individual countries. That all men are by nature equally free and independent and have certain inherent rights, of which when they enter into a state of society, that's what state actually means. The people in their status in society in Idaho, that's why it's the people of Idaho, or the people of whatever country you're in. They cannot, by any compact constitution, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. Government was not instituted to deprive us of that right there. This is a clear limitation on government from its inception of the creation of this nation called America. This is the ideology of this nation at its roots, right here. That all power is vested in and consequently derived from the people. That magistrates are their trustees and servants, and at all times amenable to them. What does that mean? That means when we come in there, we are the law sayer, right? They are the servants, and they are to ensure justice. And we'll get into trustees later because I don't want to try and confuse you, but there's some stuff about trusts. Sesta KV trust. Okay. That government is or ought to be instituted for the common benefit, protection, and security of the people. Nation, right? Nation or community. Doesn't say state, does it? Because again, the people in the state, their status in society is what the state is. So, of all the various modes and forms of government, that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectively secured against the danger of maladministration, and that whenever any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, unalienable, indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal. What they're actually directing this in part to is the English crown, because they just separate it. But this is laying down the fundamental law of this nation. Fundamentally, cannot be altered. That no man, look at that. Here it is. Here's that chapter 40 of the Magna Carta. That no man or set of men are entitled to exclusive, maybe not that part, pardon me. That no man or set of men, I know Chris loves this one, he's quoted this before. That no man or set of men are entitled to exclusive or separate emoluments or privileges from the community. I believe that's actually in the Texas Constitution. But in consideration of public services, public servants, which, not being descendable, neither ought the office of magistrate, legislator, or judge be hereditary. That's right. That the legislative and executive powers of the state should be separate and distinct from the judicate. And that what they're doing is they're creating our foundation of government here. Because in England, they didn't have a separation of powers. But this is the law, laying down the law of our ideology, of our not only our form of government, but how it's supposed to operate and function, and the limitations right here that are not supposed to be happening. These were very smart men back then. Don't underestimate them. They're very brilliant men. Okay? So, and that the members of the two first may be restrained from oppression by feeling, by feelings. We don't care about your feelings, and participating the burthens of the people. They should, at fixed periods, be reduced to a private station. That's us in the private, guys. Return into that body from which they were originally taken. That's the body of the people in the status of society. And the vacancies be supplied by frequent, certain, and regular elections in which all or any part of the former members to be again eligible or ineligible as the laws shall direct. The laws, right? The Constitution, the Bill of Rights. That's the laws we're talking about. Not the code, not the statutes. Okay? So from there, doesn't the law dictate how the president comes into being and how often he can run, and that he must be a natural born citizen, blah, 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 right? Because that's what the law says. It's been ordained and established. That's where they get this. Some of this verbiage you'll see throughout history in our stuff, and for good reason, because this is it. That elections of members to serve as representatives of the people in assembly ought to be free. That's supposed to come from the pool of the people, from that body, right? Right there, back into the private station, into the body of the people. And we have to be free. So if we're electing these representatives and we're not free people, what's going on here? And that all men, having sufficient evidence of permanent common interest with and attached to the community, have the right of suffrage, that's the right to vote, and cannot be taxed, or deprived of their property for public uses without their own consent or that of their representatives so elected, nor bound by any law to which they have not in like manner assented for the public good. But right there, cannot be taxed or deprived of their property. You can't be taxing our property. That's what the Boston Tea Party was about, right? That was for just taxing the tea. We're not supposed to be being taxed on an individual basis. That all power of suspending laws or execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not be exercised. We call that treason, a capital offense. That in all capital and criminal prosecutions, a man hath the right. Okay, this is right here where this is talking about, where it's coming through the right to a speedy trial, right? But we can't quite seem to figure out where the right to a trial by jury comes from and how it works. Well, let me show you. How convenient that they left it out. But there it is. That in all capital criminal prosecutions, a man hath the right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses. Right? You get to confront them. That's your right. To call for evidence in his favor. A denial of that's called a denial of exculpatory evidence. And here it is. See the comma right here? There's a comma. And I'm going to read from this comma to the next one. Let's see if we all get it. And to a speedy trial by an impartial jury of his vicinage. What? Next comma. Without whose unanimous consent he cannot be found guilty. Right there declares the right to a trial by jury. Is that not mandatory? Is the language not there? Is it not directory of exactly how this right works? Yes. But this is knowing what your rights are and where they come from in law. So when you want to go in and demand your right to a trial by jury, your right to a speedy trial, you cite Virginia Declarations of Rights, June 12, 1776, Article 8. Right there, as it is written in law. And to give it further effect in source and rationale, we either have an IQ problem or we have an education problem. Because right here in the annotated Constitution, under source and rationale, these rights come from the Magna Carta to the Virginia Declaration of Rights, and they're into the 6th Amendment. And then we'll go right to the 9th Amendment that says there are other rights retained by the people that shall not be, right, denied or disparaged. You have to be the law sayer. So there it is, in writing, in the plain English, how the right to a trial by jury works. And then when we talk about the Seventh Amendment incorporates this right shall not be inviolate. But then they say, well, except in civil, but see, that's the thing. At the common law, that's why it says to demand the cause and nature. It's all supposed to go through this process of your right to a trial by jury. But they try to construe it as it says in all capital or criminal prosecutions. Yeah, that's because there's not supposed to be a distinction between criminal and civil, except for in declaring the nature and the cause of action. That probable cause they've construed through time to deceive us, right? That works out to what is the cause of action and what is the nature of your cause of action? Is it criminal or civil in nature? Because that dictates the remedy, right? It doesn't dictate the process, it dictates the remedy. The process is still the same. Whether it's criminal or civil in nature, you have the right to a trial by jury, and without whose unanimous consent, you cannot be found guilty. Plain and simple. Nor can he be compelled to give evidence against himself, right? That no man be deprived of his liberty except by the law of the land or the judgment of his peers. So when we're talking about the law of the land, that comes from the Bill of Rights, not statutory law and not the fake made-up code, which I'm going to expose that at some point in time. Again, I don't know if I'll do that tonight. About a half an hour. I got about 45 minutes and I'll be done for tonight. This might sound familiar, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Really? That's almost verbatim the Eighth Amendment, ain't it? Where do you think they get that stuff from? That's why they were saying, why do we need a Bill of Rights? We already have one right here. This stuff's supposed to be self-evident. Right? Ooh, this is good. That general warrants, whereby any officer or messenger may be commanded to search suspected places without evidence of a fact committed, or to seize any person or persons not named, or whose offense is not particularly described and supported by evidence, are what? Grievous and oppressive, and ought not to be granted. So when we're talking about the Fourth Amendment, no warrant shall be issued, but upon probable cause. Somebody has to do an affidavit, right? And it has to be the nature and cause of action must be stated in order to get the warrant. You put those two and two together here, how that's supposed to work, right? Nor cruel and unusual punishments inflicted, violating the Fourth Amendment. That in controversies respecting property and in suits between man and man, the ancient trial by jury is preferred to any other and ought to be held sacred. Property, rights, an aggregate of guaranteed rights. You don't have to make your property private. It's already your property private. Claim it. Let them give rebuttal. They won't be able to give rebuttal. It's fraud. And they're not going to present fraud. So this is where I try to teach people, quit trying to make their arguments for them. You stand your ground on the law, standing in law. Stand on your own property. Claim and exercise your rights as you see fit. So long as you do not cause injury and harm to another man, no man has a right to a cause of action against you. Corporations are dead entities. It has to be a suit between a man and a man. And if we want to get serious, Erie Railroad versus Tompkins lays down jurisdictions and suits, right? They must be in like kind. Therefore, if you're a man, and this is where we get into objecting to the personal jurisdiction, doing your notice a notice of special appearance, not appearing generally, but specially under threat, coercion, duress, right? Objecting to the personal jurisdiction, because this is not a suit between a man and man. This is between some artificial fiction, artificial person, not a man. Remember, 3 terms: man, woman, or one of the people. That's the only 3 terms you ever want to use, as it is written, between man and man. Okay? Man actually here in law actually means mankind, because that comes from the Bible. God created man in his image, mankind. It doesn't mean male, although a lot of people will try and construe, and yes, in certain parts of the law, back in the day in the English common law, which is part of what we separated from, is that, well, the man has all the, and per the common law, in certain instances, when it comes to family, yes, this is true. The man is the head of the household. He is the king of his castle, right? What the man says goes. That's supposed to keep hierarchy within the home, within the castle. And that's supposed to be some respect and duty, right? As the man of the house, that imposes duties to take care of his wife, to take care of his children. That imposes those duties. So don't think it's supposed to be, well, I'm the man of the house and I can just do whatever the hell I want and I can treat you like crap if I feel like it. No, it's not what God said. It's not what the Bible says. That imposes duties upon you as the man, as the father, as the husband of the house, to perform and protect your family, to secure your safety. That's your duty. That the freedom of the press is one of the greatest bulwarks of liberty and can never be restrained but by despotic governments. So, for those of you that get those gag orders, right? Freedom of the press, freedom of speech, happens to be one of the greatest bulwarks of liberty, fundamental liberty interest. That's why it's under the First Amendment. Congress shall make no law regarding the right to speak on anything and to publish it. That's the freedom of the press. And it can never be restrained but by despotic governments. So for those of you out there that get them restraining order or gag order or whatever, well, you're being despotic, aren't you? You're depriving a fundamental right. Happens to be one of the greatest bulwarks of liberty and can never be restrained but by a despotic government. Capital felony treason. That a well-regulated militia composed of the body of the people, which is exactly why the Second Amendment reads the way it does, trained to arms, is the proper, natural, that's right, natural right, comes from the law of nature, to defend ourselves. What was that right there at the very beginning? Right, in the very beginning, right? The enjoyment of life and liberty with the means of acquiring and possessing property, right? We have the right to defend that. Naturally. And safe defense of a free state. Notice what the Second Amendment says, right? The necessary security of a free state, the right of the people to keep and bear arms, shall not be infringed. Because that's what it says right here. Now get this, that standing armies in time of peace should be avoided. as dangerous to liberty. We are not supposed to have a police force. They said back then, in our ideology of this nation, that we are not to have anything but a militia, which is composed of everybody. Everybody of the people, right? And for the safe and defense of a free state, we're going to have them trained to arms, right? And that in all cases, the military should be under strict subordination to and be governed by the what? The civil power, us, people. All political power is inherent in the people. Fundamental principle, ideology of this nation, right? Where was that? Oh, does it come right there at the beginning? Yeah. Right here. That all power is vested in and constantly derived from the people, the civil power. That the people have a right to a uniform government and therefore no government separate from or independent of the government of Virginia ought to be erected or established within the limits thereof. Now, this could be construed as, oh, well, this only applies to Virginia then. Yes and no. Problem is we have to understand that Virginia, Jamestown, Virginia, was established in 1603 with the first charters of Virginia in 1606. Virginia is the founder of America. 1620 was the Mayflower. That happens to be, what, 17 years later. Okay, Virginia was actually all of the whole eastern coast there. Yep. And then it was divided up. And right before this, it was given, right, in the Virginia Constitution. This is why the Virginia Constitution is important. Not only that, this, let me read it right out of my Annals of America, Volume 2, 1755 through 1783, Resistance and Revolution, because see, even on here, they're hiding the verbiage that goes between here and there. But not in my book, they didn't. How deceiving, right? Virginia Declaration of Rights. Virginia Declaration of Rights was in many ways a central document of its era, drawn upon by Jefferson for the opening paragraphs of the Declaration of Independence. It was widely copied by other colonies. There it is. It was adopted by other colonies. But they weren't colonies at this time, were they? They were states. Became the basis of the Bill of Rights in the Constitution and had considerable influence in France at the time of the French Revolution. It was written by George Mason and adopted by the Virginia Constitutional Convention on June 12, 1776, as the theoretical foundation of all government. Source, Thorpe, 7 pages, 3812 through 3814. And we'll go down to the bottom here. And what does that say? Oh, they actually took that off of here. Hiding it again. Wow. Because it used to say the source was Thorpe 7, blah, 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 blah. It used to say that right here. But as you can see, adopted unanimously June 12th, Virginia Constitutional Convention of Delegates drafted by Mr. George Mason. So, now, that no free government or the blessings of liberty can be preserved to any people but by a firm adherence to justice. That's why in the Constitution of the United States of America, in the preamble, it says, we the people, in order to form a more perfect union, establish justice. We the people establish justice, not government, right? Moderation, temperance, frugality, and virtue. And by frequent reoccurrence to fundamental principles. That religion, or the duty which we owe to our Creator, and the manner of discharging it, can be directed by reason and conviction, right? Not by force or violence. And therefore, all men are equally entitled to the free exercise of religion. It is the free exercise of religion, not to be free from religion. As it is written, all men are equally entitled to the free exercise of religion. I repeat, not to be free from religion, according to the dictates of conscience. Wow, imagine that. Because constitutions are the internal dictates of the mind. Government is a figment of the imagination. And that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. Morally and ethically, fundamentally, right? We are a Christian nation. And this is morals and ethics that this nation is built on. The organic law, the fundamental law, the common law. Fundamentally, cannot be altered. This is our nation. So, the right to a speedy trial is a right of an accused, but it serves the interest of defendant and society alike. So we're back here when I was talking about this is the succession of law. And I can take you back to the Magna Carta, which I kind of wanted to do, but we'll just leave that for now. You can find it right here. It's in here. Anglo-Saxon, right? And we switched from Anglo-Saxon to Anglo-American Christian. That separation from the Roman Catholic. Hey, look, there's the Assize of Clarendon from 1166. That happens to be where initially where our right to a speedy trial came from, or a right to a trial by jury. It's crazy, dude. They used to use hundreds of men as the jury. It's crazy. But we want to go back. I want to show you the Magna Carta. There we are. Magna Carta. It would be, technically speaking, Magna Charta. Oh, come on. Stupid, crazy stuff. All right. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy, to the archbishops, all these barons, blah, 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 sheriffs, stewards, servants, and to all his bailiffs, liege subjects, greetings. Know that, having regard to God, and for the salvation of our soul, and those of all of our ancestors and heirs, and unto the honor of God, and the advancement of his holy church, and for the rectifying of our realm, we have granted, as underwritten, by advice of our venerable fathers, blah, 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 all England, Cardinal, blah, blah, all these other weird names. And this is the history right here. All these people owned land, okay? In the first place, we have granted to God. This is it. Number one, why you have the rights that we do. Because these people gave all of our rights and granted them to God so that no man could interfere with them. This is fundamental principles of law in originating where our rights come from is right there in that first sentence of the Magna Carta. Okay? In the first place, we have granted to God, and by this our present charter, Magna Charta, great charter of liberty, confirmed for us and our heirs forever, that the English church shall be free, and shall have her rights entire, and her liberties inviolate. Okay? I want you to understand about this document is that these people went in and put a sword to King John's throat and told him, you will sign this Magna Carta or we will kill you, and we will go throughout the castle and we will kill your entire bloodline, all of these people, all of your faithful servants and all that other stuff, because we're tired of your crap. We're tired of your tyranny. In 1215. Okay? And we will that it be thus observed, which is apparent from this, that the freedom of elections, which is reckoned most important and very essential to the English church, not the Roman Catholic Church. Two different churches here. Okay? They're trying to separate from the Roman Catholic Church. This would be the Christian people trying to separate from the Roman Catholic Church. Okay. Let's see. Church, we of our pure and unconstrained will did grant and did by our charter confirm and did obtain the ratification of the same from our Lord, Pope Innocent III, before the quarrel arose between us and our what? Barons? What is that? And this will be, we will observe. And our will is that it be observed in good faith. Ever heard that? Good faith reliance? By our heirs forever. We have also granted to all free men of our kingdom, for us and our heirs forever, all the underwritten liberties to be had and held by them and their heirs, of us and our heirs forever. This is why the Magna Carta is in full force and effect today. As of right now, the Magna Carta is in full force and effect because of this clause right here. And rights cannot be diminished. If any of our earls or barons or others holding of us in chief by military service shall have died, and at the time of his death his heir shall be full of age and owe relief, we shall have his inheritance by the old relief, to wit, the heir of heirs of the earl and the whole barony, whatever, of the earl and blah, blah, blah. But that's the main stuff right there. Perpetual, forever. If, however, the heir of anyone aforesaid has been underage and in wardship, let him have his inheritance without relief and without fine when he comes of age. And when we talk about sui juris, coming of lawful age, of sound mind, perfectly capable of handling your administrative duties. Back then it was 14. Nowadays it's 21. The guardian of the land of an heir who is under age. The land? That's right. Government doesn't own the land. People do. Shall take from the land and the heir nothing but reasonable produce, reasonable customs, and reasonable services, and then without destruction or waste of men or goods. So you're supposed to take from the land without waste or destruction of men or goods. Capitalism, that's what we came up with, our founders came up with. Committed the wardship of the lands and as such minor to the sheriff or to any other who are responsible to us for its issues. And he has made destruction or waster of what he holds in wardship. This is all just kind of da-da-da-da-da. But neither we nor our bailiffs will seize any land or rent for any debt Uh-oh. As long as the chattels, right, of the debtor are sufficient to repay the debt, nor shall the sureties of the debtor be distrained. But this is part of that English law, right? Oh, See, if one who has borrowed from the Jews any sum, great or small, die before the loan be repaid, the debt shall not bear interest while the heir is underage, right? Because your debt is supposed to go through succession, right? You don't get out of the debt, but it's to them, not to government. Nothing in future shall be given or taken for a writ of inquisition of life or limbs, but freely it shall be granted and never denied. No bailiff for the future shall, upon his own unsupported complaint, would that be like a police officer, that standing army crap, put anyone into his law without credible witnesses brought for this purposes. That's right. No free man shall be taken or imprisoned or deceased or exiled or in any way destroyed, nor will we go upon him nor send upon him except by the lawful judgment of his peers or by the law of the land. There's number 40 right here. To no one will we sell, to no one will we refuse or delay right or justice. That's weird. Let's see. Those three right there are pretty good tight ones, right? So that's pretty much it for the Magna Carta. So a lot of this other stuff has been changed and gotten rid of, but let's see. Let's take a look at here. Yep. Okay. All right. So there's your fundamental law, the organic law, the law of this nation. Actually, I'd like to show you one more before I end. What? I wonder why. All right. Declaration by the representative of the United Colonies of North America now met in Congress at Philadelphia, setting forth the cause and necessity of their taking up arms. Why did they do that? This is July 6, 1775, folks. This is in the First Continental Congress. See now there, they put it in here. Source, documents illustrative of the formation of the Union of the American States. Government Printing Office, 1927. House document number 398. Right? There it is. In plain English, it's in our law, in our history of law, because this is the start of the separation. Our forefathers, inhabitants of the island of Great Britain, left their native land to seek on these shores a residence for civil and religious freedom. That's the reason why they left. Plain and simple. In writing, right here. At the expense of their blood, at the hazard of their fortunes, without the least charge to the country from which they removed, by unceasing labor and unconquerable spirit, they effected settlements in the distant and unhospitable wilds of America, then filled with numerous and warlike barbarians. Uh-oh. Truth be known, when we showed up over here in 1603. Right? That these lands were filled by numerous and warlike barbarians. They weren't civilized society. They were freaking murdering each other. In fact, the ones that we made friends with when we first come over here, and see, this is why we need to comprehend who all came over here in 1603. For civil and religious freedom, the good Christians came over here. Guess who followed? The redcoats and the bluecoats. That's right. We had three types of people that came over here. So when we say that, or people say that, oh, well, the people came over here, the white man came over here and murdered all these Indians and took their land. That is not true. There were some that were semi-civilized, and we made friends with those Indians. And those Indians actually begged for protection. Why? Because we had muskets, and we had gunpowder, and we had pistols. Yeah, that's right, we did at that time. So, we traded with the Indians, and we defended the good ones from the barbarians, the warlike ones. And there was multiple people on the beaches and in the inland there that were already laying dead and rotting. And there was it was explained that there was a plague that had come through, and a lot of people died from feast and famine because of these numerous and warlike barbarians. Uh-oh. Cannot play video. Well, why not? Can't watch my own video? That's crazy. Societies or governments vested with perfect legislatures were formed under the charters from the crown. What charters are we talking about? The first charter of Virginia in 1606. Then 1609 was the second. And I can't remember when the third one was. Interesting reads as well, which is also right here on Avalon. Yale.edu. The mutual benefits of this union became in a short time so extraordinary as to excite astonishment. It is universally confessed that the amazing increase of the wealth, right? Amazing increase of the wealth, strength, and navigation of the realm arose from this source. What does that tell you, folks? That the good Christian people that settled here to begin with got along with everybody. And it was too good because it excited astonishment. And let me get into this, right? And the minister who so wisely and successfully directed the measures of Great Britain in the late war publicly declared that these colonies enabled her to triumph over her enemies. How? Towards the conclusion of that war, it pleased our sovereign to make a change in his counsels. Uh-oh. From that fatal moment, the affairs of the British Empire began to fall into confusion and gradually sliding from the summit of glorious prosperity to which they had been advanced by the virtues and abilities of one man, are at length distracted by the convulsions that now shake it to its deepest foundations. The new ministry, finding the brave foes of Britain, though frequently defeated, yet still contending, took up the unfortunate idea of granting them a hasty peace and then subduing her faithful friends. So what they did was, without war, essentially they were at war, but it wasn't, it was somewhat violent, but these people were calm Christian people, right? They didn't take up arms against their fellow man, other than and in self-defense, which if you read the 1606 Charter of Virginia, the first Charter of Virginia, you'll see that we have always had the right to arms while out on adventure to defend ourselves from whatever foes we may run into. All throughout history, since arms have ever come about, we've had the right to keep and bear arms for self-defense. And then they played a trick on them. Oh yeah, okay. We'll grant peace. All right, we're kicking the shit out of you, but we'll grant peace. And as soon as we turned our back, they stabbed us in the back, and they killed the faithful friends. These devoted colonies were judged to be in such a state as to present victories without bloodshed, right? Without bloodshed, because they were good, peaceful Christian people. And all the easy emoluments of statutable plunder. Emoluments and statutes have been around for a long time, which is why we're not supposed to have statutes today. Bills of attainder are prohibited. The uninterrupted tenure of their peaceable and respectable behavior from the beginning of colonization, their dutiful, zealous, and useful services during the war, though so recently and amply acknowledged in the most honorable manner by His Majesty, by the late King, and by Parliament, could not save them from the mediated innovations. Mediated innovations. Parliament was influenced to adopt the pernicious project. What is the pernicious project? It's called the bar. And assuming a new power over them, have in the course of 11 years given such decisive specimens of the spirit and consequences attending to this power as to leave no doubt concerning the effects of acquiesce under it. Those easy emoluments of statutable plunder, we'll just pass a statute. We'll just tax you through statutes. Parliament was influenced to adopt the pernicious project and assuming a new power over them, having in the course of 11 years given such decisive specimens of the spirit and consequences attending this power as to leave no doubt concerning the effects of giving their consent to it, basically, is what acquiescence under it. They have undertaken to give or grant our money without our consent, though we have ever exercised an exclusive right to dispose of our own property, right? Statutes have been passed for extending the jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits. July 6, 1775, folks, beyond their ancient limits, and they're using statutes for depriving us of the accustomed and estimable privilege of trial by jury in 1775 in cases affecting both life and property, for suspending the legislature of one of the colonies, for interdicting all commerce to the capital of another. This is where income and commerce in Article 1, Section 8, Clause 3 is all things foreign. They're doing the same damn thing now, what they did back then. Interdicting all commerce on man, right there, to the capital of another. Not supposed to be doing that. These are declared acts of tyranny. Why they declared they are taking up arms? Because they don't want to acquiesce under it. They have no doubt concerning the effects of acquiesce under it. And we're going to take up arms because of this. For you extending admiralty and vice admiralty jurisdictions beyond their ancient limit, because there's only 3 jurisdictions: law, land, air, and water. Law of the land, law of the air, law of the water. But they extended it in 1845 again. 1845, they extended admiralty jurisdiction onto the land by congressional act of, I have it written down right here. Yeah. It was 1845. They extended admiralty jurisdiction back onto the land. That's a trespassable law. That's capital felony treason. Right? Fundamentally, okay. And for altering fundamentally the form of government established by charter and secured by acts of its own legislature solemnly confirmed by the crown. For exempting the, here we go, for exempting the murderers of colonists from legal trial and in effect from punishment. Mock trials is what that all came about. And here they are in 1775, declaring the causes and necessities for taking up arms. For erecting in a neighboring province, acquired by the joint arms of Great Britain and America, a despotism dangerous to our very existence, and for quartering soldiers upon the colonists in time of profound peace. Police officers, are we not quartering them today? If our tax dollars are paying their wages, and they're taking those wages and buying homes in our neighborhoods and in our communities, are we not quartering them? We are paying for their homes. It has also been resolved in Parliament that colonists charged with committing certain offenses shall be transported to England to be tried. Why? So they can protect them by mock trials, and nobody would know the difference. But why should we enumerate our injuries in detail? By one statute, it is declared that Parliament can of right make laws to bind us in all cases whatsoever. Let that sink in for a minute. But why should we enumerate our injuries in detail? By one statute, it is declared that Parliament can of right make laws to bind us in all cases whatsoever. It's in the Declaration of Independence. Let the facts be submitted to a candid world that they had done that, right there. That they were legislating for us in all cases whatsoever. Are we not back under that again? Can you name one case that is heard at the common law and has nothing to do with the establishment, support, or management of government? The legislature, the executive, and the judicial, right? Because that would be establishment, would be the legislature. Support would be the executive branch to execute it, and the judicial branch to manage it. Those are courts of the United States. Where are the people's courts, the common law courts? Have you legislated for us in all cases whatsoever again? Did we not take up arms once before for this? I don't advocate for this. I'm just reading history. This is history repeating itself, right? Why do you think they want to disarm us? One little bit at a time. Oh, well, if somebody says that you've got some sort of mental health issues over here, we should be able to come in and take their guns and then deal with it later. No, that's not due process of law, right? You have to get the consent of the governed and a jury of 12 of his peers, our peers. But this is the reason why we teach that petition of remonstrance, because we cannot claim that we are under absolute despotism because our petitions, one, haven't been filed. Two, they haven't been met with repeated injuries. So until we exercise the first line of defense, we cannot, in all good logic and reason and good conscience, take up arms and exercise the last line of defense. Although we better get on this quick, because the way things are looking, they're starting to chip away at our right to keep and bear arms. So we need to start filing these petitions of remonstrance and getting in there and demanding that we alter, reform, or abolish that policy, or that we remove these people from duty through impeachment proceedings, right? What is to defend us against so enormous, so unlimited a power? Not a single man of those who assume it is chosen by us, or is subject to our control or influence. But on the contrary, they are all of them exempt from the operation of such laws. Oh, Obamacare. Well, we just exempt ourselves from that. They put that in the loopholes in there that they could go in and do this, that, or the other and get out of being part of Obamacare. On purpose. Well, there's 4,000 pages here. We have to pass it in order to see what's in it. Ugh! There's no logic or reason in that. I cannot believe that. Who in their frickin' of sound mind, using logic and reason, would say we have to pass it before we can figure out what's in it? No, you have to read it before you can even vote on it. Per the law, you have to read it 3 times. Good luck. Go read that 4,000-page document. You cannot put something to a vote that you know nothing about. Come on, seriously? Common sense here. I know common sense ain't common, but geez, give me a break. And American revenue, if not diverted from the obstinate purposes for which it was raised, would actually lighten their own burdens in proportion as they increase ours. Will that be taxation without proper representation is theft? They increase our taxes and impose taxes upon us without our consent, only to enrich themselves. We're right back to the same old crap, without a shadow of a doubt. We saw the misery to which such despotism would reduce us. We, for 10 years, incessantly and effectually besieged the throne as supplicants. We reasoned, we remonstrated with Parliament in the most mild and decent language. Beautiful language in John Gentry's petition of remonstrance. Beautiful. And on that note, right there, put that in your mind. A petition of remonstrance throughout history has been our rights. Clear back to 1215 of the Magna Carta. Okay? And there it is, in law, as it is written. We remonstrated with Parliament. We have the right to a petition of remonstrance in our form of government. That is a right retained by the people. Administration sensible that we should regard these oppressive measures as free men ought to do, sent over fleets and armies to enforce them. The indignation of the Americans was roused. It is true, but it was the indignation of virtuous, loyal, and affectionate people. A Congress of delegates from the United Colonies was assembled in Philadelphia on the 5th day of last September, we resolved again to offer a humble and dutiful petition, a petition of remonstrance, right, to the king, and also addressed our fellow subjects of Great Britain. Subjects, part of the stuff we Brexited from. Subjects are from Great Britain. What would that be in the 14th Amendment? And subject thereof. We are not subjects. We are man, woman, one of the people of the state, one of the people of the several states. We have pursued every temperature, every respectful measure. We have even proceeded to break off our commercial intercourse with our fellow subjects. What's Trump doing right now? Breaking off the trade. People don't see it. I do. I see what Trump is doing because I've read this stuff. I know what's happened in history. I know what our founders went through. Clear back to 600 AD, I've studied. A lot of it's from right here. Some of it's from right out of them books. Been at this for 24 years, folks. This is not new to me. I love y'all. That's why I'm here. That's why I'm doing what I'm doing. So, if you learned something here tonight, and you like what I'm doing here, and you want to help support me in doing what I'm doing and make a donation to me personally, on the page is an address for the office. You can send me postal money orders, cashier's checks, cash if you want to send it through the mail. I also, through PayPal, if you like to do PayPal, it's just my name, Kirk_Pendergrass at hotmail.com is my PayPal. I'll put it on here. Other than that, it's 6477 West Fairview Avenue, Suite C, as in Charlie. Boise, Idaho, 83705. And there you go. So much love to you folks out there. I will be on Monday nights doing just this, and I'm starting to label them. Episode 1. Oh crap, I forgot to record on Zoom. I guess I'll have to download this and get it over to YouTube. So a few different places to go for us. Obviously right here on the page, like, follow, and share here. Get notified when we go live. That's a good one to select. Okay. Get notified under the following there. WeThePeopleV50.com. John Gentry just uploaded his petition of remonstrance that he filed in the Tennessee Senate today. We'll be talking about that either on probably Wednesday. And we also have some updated stuff going on with the Texas case. As soon as Chris gets done with that, we'll be bringing that back out. That might be not until next week. The E-Clause LLC group, previously known as Amber and Stephen, has now been renamed. There are files in there. In the files section, there's all sorts of good stuff going in there. Kirk's Law Corner group, this is the page. Then there's the group. My group is specifically for law stuff, just like a law library. It's not for memes. It's not for videos unless they are educational, and I still vet them. I still look at them. If it's not clear and precise and it's just somebody else out there trying to promote themselves, I'm not going to share it in there. It's strictly for the law stuff, to keep it clean, to keep the feed clean. So we're not just, a dumping ground for all sorts of stuff, to make it easy to find law stuff in there specifically. And then there is the group, We the People v. the 50 United States. That one's got almost 13,000 people in it. So that's another one that you can get into. Other than that, that's all I got. And much love to the rest of you out there. Hang in there, one day at a time. Educate. Gain this knowledge, folks. Got to gain this knowledge. We just have to do it. Much love. God bless. See you Wednesday.